our panel now is on rights, norms, and global justice. And with us today we have Alexander Kaufman, Associate Professor of Political Science, University of Georgia, and my graduate school classmate. And Brooke Ackerly, Associate Professor of Political Science and Philosophy at Vanderbilt University. And Abdulaziz Sachedina, Francis Myers Ball, Professor of Religious Studies at the University of Virginia. Wendy Wong, Assistant Professor of Political Science at the University of Toronto. And proof positive of the merits of the UCSD Political Science program, where she obtained her PhD. And Gershon, Shafir, Professor of Sociology and Director of the Institute for International Comparative and Area Studies at UC San Diego. And Babak Rahimi, Assistant Professor of Literature at Rahimi? Assistant Professor of Literature at University of California, San Diego. So social choice theory, roughly speaking, is the logic of combining human judgments or human goals into either a single decision or a ranking or incomplete ranking. And it's a quite highly formal and mathematical, yet quite useful discipline, which is where Amartya Sen gained his highest professional recognition. He reminded us several times yesterday. And so his 1998 Nobel Prize was for, I'm closely paraphrasing now, was for studies in social choice, welfare measurement, and poverty. And his capabilities approach to welfare measurement and poverty is recognized both for its intellectual merit and for its effects in improving the lives of millions of people. Development was once measured and designed with an eye to increasing a country's gross national product. And that metric only recognizes a single facet of human experience and causes serious distortions. For example, it neglects the distribution of wealth between individuals in a society, and it neglects the personal and political freedoms. You know, nobody has the right to free speech or free association, but the average gross national product went up by $50, so things are better now. So in contrast, the capability approach asks us to measure valuable beings and doings, such as life expectancy, nutrition, health, security, liberties, self-respect, participation in governance, and the like, as appropriate in a given application. Sen doesn't have, you know, a recipe prescribed for every situation. That's for the people involved to work out. So the capability, the approach is now used as a metric to measure and design development activity, and it's summarized at page 233 of the Idea of Justice. I quote, "The capability approach focuses on human life and not just some detached objects of convenience such as incomes or commodities that a person may possess, which are often taken, especially in economic analysis, to be the main criteria of human success. Indeed, it proposes a serious departure from concentrating on the means of living to the actual opportunities of living." Close quote. The capabilities approach is developed and presented in a series of rigorous and sophisticated essays by Amartya Sen, Martha Nussbaum, and others. It can be simply understood as an emphasis on actual human lives and freedoms rather than on the average wealth of a country, or rather than the old utilitarian measure of the maximization of total net pleasure in a society. So with that introduction, we'll start in the order that you're sitting, unless you have another preference.
All right, first I'd like to thank the organizers, Fana, Gerry, and most of all Professor Sen for giving us a remarkable body of work. Now to the argument. Sen's account of the capabilities approach carefully avoids any attempt to describe perfectly just institutions. But Sen does argue for a specific informational focus to inform arguments, judgments of justice. In particular, Sen argues for an approach that focuses attention on the degree to which members of a society are free to choose what form of life to lead. The priority of freedom in Sen's account remains one of the theory's most controversial features. In overestimating the importance of freedom, critics argue, Sen's approach would exclude from central concern aspects of the person's circumstances that are important, essentially important from the standpoint of justice. In particular, Gerald Cohen argued, if capabilities are merely freedoms that the person has discretion to exercise, then states of the person which he, the person, neither brought about nor was in a position to bring about, would not count as objects of fundamental concern. Sen, however, rejects the view that in order to experience freedom, a person must actually bring about states of affairs. Rather, Sen argues, a person's freedom may be reasonably assessed in terms of the person's ability to benefit from certain results, regardless of whether the person brought about those results. Sen calls this notion of freedom without control effective freedom. The judgment that a good does not fall within a person's power to choose would not, therefore, establish that it is not a fundamental concern for the capabilities approach. Cohen, however, argues that this response is unpersuasive because Sen fails to provide a compelling account of freedom without control. Rather, he argues, Sen vacillates between two different interpretations of effective freedom, one strong and one weak, and neither interpretation, he claims, describes freedom without control. Under the weak interpretation, the levers of control are exercised consistently with the person's preferences, but not because the person would want them exercised in that way. For example, an international agency over which I have no influence implements a policy that I favor, designed to reduce the incidence of malaria. Implementation of the policy satisfies the weak interpretation, since the policy conforms to my preferences, but I've exercised no control over the decision. Cohen, however, argues that implementation of the policy does not, in fact, enhance my freedom. When freedom is exercised, Cohen claims, two conditions are satisfied. First, the world conforms to my will, and second, my choice determines the result. I'm going to refer to these conditions collectively as the decisive choice condition. Unless this condition is satisfied, Cohen argues, my freedom is not enhanced when the world conforms to my will. And under the weak interpretation, the decisive choice condition is not satisfied. As a result, Cohen argues, the weak interpretation doesn't describe a form of freedom at all. Note, however, that Cohen's argument involves two strong assumptions about the nature of freedom. First, Cohen assumes that freedom is realized only in cases in which a person exercises a power. Second, he assumes that freedom is only realized when the person's choice determines the resulting state of the world. Neither of these claims is obviously true. Suppose, for example, that an international agency persuades a totalitarian regime to release a political prisoner. After the prisoner has been released, the world conforms more closely to her will, but not as a result of her choice. According to Cohen, then, the prisoner's release does not enhance her freedom, since she hasn't exercised the power, and her choice didn't produce her release. Nevertheless, it would seem that any reasonable account of freedom must view her release as increasing her freedom. Cohen rejects this view because he argues from a narrow interpretation of the idea of freedom. In particular, Cohen privileges an exercise concept of freedom, of the type favored by Charles Taylor, over the more widely accepted opportunity concept of freedom. Exercise concepts of freedom view freedom as involving essentially the exercise of control over one's life. Opportunity concepts, in contrast, view freedom as essentially concerned with what options are available to the person. Gerald McCallum's influential triadic account of freedom provides an account of the structure of the opportunity concept. In McCallum's account, freedom involves a relationship between three elements: a person, a constraint, and a potential action. If an effective constraint on the person's ability to act is released in McCallum's account, the person's freedom is enhanced, even if the person's choices do not produce that result. Under an opportunity account like McCallum's, then, interventions that secure the person's good can enhance freedom even when the person's choices do not secure that benefit, as in the case of my released prisoner. Cohen's claim that freedom is realized only if the decisive choice condition is realized, therefore depends upon the assumption that an exercise concept of freedom must be privileged over opportunity concepts. And even as an interpretation of the exercise view, Cohen's account is idiosyncratic in requiring satisfaction of the decisive choice condition. As I discussed in the paper, neither Rousseau's nor Taylor's classic accounts of exercise freedom require satisfaction of that condition. So since a wide range of acceptable accounts of freedom under both the exercise and the opportunity concepts recognize that an increase in freedom does not necessarily require decisive choice, the fact that the weak interpretation does not require decisive choice does not establish that the weak interpretation does not describe a form of freedom. Cohen's critique of the weak interpretation, therefore, fails. Now let's consider Cohen's critique of the strong interpretation. Under the strong interpretation, a person's preferences are satisfied because they are that person's preferences. For example, a proofreader corrects the text as he does because he knows I would want it to be corrected that way. Such a case, Cohen argues, does not exhibit freedom without control because in such a case, I continue to operate the levers of control. My exercise of control is indirect, but I still, Cohen claims, control what is done to my manuscript. But to control a process means to have directing influence over that process. A person exercising indirect control must therefore have a final say about what is done. So does a person whose preferences are honored because they are her preferences necessarily exercise this kind of influence? Well, consider Sen's example of the unconscious accident victim. This victim, if conscious, would prefer treatment B to treatment A. A friend who knows his preferences convinces his doctor to choose treatment B because the victim would have preferred it. The victim's preferences are therefore decisive because they are his preferences. But is the victim's influence plausibly characterized as indirect control? Does he have a final say about what the doctor does? The correct answer would seem to be no. If the doctor refused to satisfy his preferences, the victim could not compel him to do so. Since the world conforms to the victim's preferences because he has such preferences, his freedom is therefore enhanced. But since this result is not determined by his choices, he doesn't possess control. Contrary to Cohen's assertion, then, the strong interpretation does not appear to provide an account of freedom without, the strong interpretation does appear to provide an account of freedom without control. And if this conclusion is correct, then Cohen's critique of the strong interpretation fails as well. Cohen's critiques of Sen are, moreover, subject to the more decisive objection that they're not directly relevant to Sen's arguments. The form of freedom of choice that Cohen criticizes is not, in fact, the form of freedom of choice that Sen intends to describe. In particular, Cohen focuses on freedom of choice over individual functionings, while Sen focuses on freedom of choice over vectors of co-realizable functionings. A person's capability set contains the vectors of such co-realizable functionings that are available to the person. And effective freedom, in Sen's account, involves the freedom to choose over the vectors contained in that set. The implementation of an epidemiological policy that reduced the incidence of malaria would, for example, enhance the person's freedom by changing the contents of the set of vectors available to the person. Implementation of the policy would not improve the person's ability to choose among individual functionings. The person would not, as Cohen notes, be provided to choose between life with and life without malaria. Nevertheless, implementation of the policy would increase the person's freedom by changing the contents of his capability set, in particular by replacing an undesirable vector of functionings with a desirable vector. Since Cohen assumes that Sen's account of effective freedom is designed to realize choice over individual functionings, his objections mistake the focus of Sen's argument. Therefore, even if Cohen argued persuasively that neither the strong nor the weak interpretations, as applied to individual functionings, describe freedom without control, his critique of Sen's notion of effective freedom would still fail. Sen can then plausibly claim that his approach's emphasis on freedom extends the descriptive and analytic range of the literature on distributive justice. The character of this contribution is illustrated in a recent exchange between Ronald Dworkin and Andrew Williams. In order to illustrate the nature of a deficit in capabilities that cannot be redescribed as merely a deficit of welfare or resources, Williams offers the following example. Anne and Bob are twins with similar endowments of talent, education, and ambition. Similar talent and education and ambition. In their society, however, preferences are not symmetrically distributed between men and women. Men in this society generally prefer to devote their time to their careers, while women generally prefer to devote a significant percentage of their time to parenting. Under these conditions, Anne will find it much harder than Bob to find a partner willing to share equally in childcare. As a result, she will either have to make larger career sacrifices than Bob in order to have children, or she'll have to abandon the idea of having children. If we assume that Anne and Bob begin with equal resources and ultimately realize equal happiness, then Anne suffers from neither a welfare nor a resource deficit. Nevertheless, Anne's capability set is inferior to Bob's because her effective freedom to choose one form of life or another is constrained in a way that his is not. Anne therefore suffers from a deficit that can be described in the metrics of capabilities, but not in the metric of welfare or resources. Dworkin argues that this example is problematic on two grounds. First, Dworkin argues that equality of resources does require compensation to address the effects of unjust discrimination. Equality of resources, he said, would therefore recognize the deficit in this case and would provide Anne with a remedy. This argument, however, is not responsive to Williams' example. Anne's problem does not result from unjust discrimination. Rather, her disadvantage results from the distribution of preferences over men and women. Even if social legislation guaranteed fair treatment by employers then, Anne would still not enjoy freedom similar to Bob's. Dworkin's second ground for objecting to Williams' example is his rejection of the claim that the inequality between Anne and Bob is morally relevant. Why, Dworkin asks, should we assume that a life that includes more domestic responsibilities and a less active career is less valuable than a life that includes a more active career and less child-rearing? That's Dworkin's response. The relevant question, however, from the standpoint of justice is not whether Bob's capability set is more valuable than Anne's, but whether or not Anne and Bob have been treated as equals. And clearly they have not. Both desired a particular set of goals, but Bob enjoyed a greater opportunity to realize that set than Anne. In terms of Dworkin's own theory of equality of resources, the arrangement fails the envy test. Anne will legitimately envy Bob's otherwise identical resource distribution, a distribution that left him freer to pursue his life plan than it left her. Andrew Williams' example therefore appears to confirm Sen's claim that his theory's expansion of the informational base upon which judgments of justice are formed allows the capabilities approach to identify failures in distributive justice that cannot be reduced to inequalities of welfare or resources.
Thank you.
So again, thank you. I want to echo Fauna. Gerry, thank you for inviting me, and Anthony and Jackie for all you've done to make it easy to be here. I want to thank Bill Zink, my children, Catherine Stevenson, for supporting my travel schedule this week and next week, and enabling my effective freedom and broader capability set and fuller range of functionings. And I want to thank all of those people who are enabling you, my fellow panelists, and you all to be here today. Pardon me? It's a big list, but it's theoretically relevant. How do we theorize about justice in an unjust world? Amartya Sen has had a strong influence on my thinking on this topic since he visited my undergraduate economics class at Williams College, and then since I read his work on capabilities as a graduate student in political theory. So it's a distinct honor that is personally fulfilling to share my ideas in this venue. In my initial framing of this project, I found the distinction between ideal and non-ideal theory illuminating. But as I followed the struggles for justice that have always informed my work, those of people whose capabilities are constrained by multiple inequalities, I've come to focus on the topic of how we do non-ideal theory. Theorists of global justice have been comfortable debating poverty as a matter of distributive justice. In this view, poverty is a matter of distributive justice because of certain institutional outcomes, that millions of people die from preventable causes, that those in poverty are more often exposed to those causes, that those in poverty are politically powerless, wealthy elites relatively more powerful with regard to those causes, wealth and income are concentrated, wealthy experience growth and wealth, while poor do not. The argument sounds straightforward, worthy of being modified or elaborated, but not contestable. Not so fast. In fact, mortality from poverty is an intersectional injustice. That is, poverty affects morality of different demographic groups of poor people differently. For example, by age, the very young, gender, women, particularly women of childbearing years, or women who have begun childbearing before reaching physical maturity, and location in relation to the food economy, conflict, exposure to natural disaster, etc. These differences are part of the everyday lives of many poor people. Therefore, redistributing income without attending to age, gender, and geographic vulnerabilities may avoid some mortality, but it will reconfigure, not redress, the everyday injustices that underlie what theorists observe as global injustice. So in this memo, I argue that a theory of global justice needs to be a theory of everyday injustice. Thank you very much, Tracy, for setting me up. A theory of everyday injustice must attend to processes and relations of injustice, not merely to the institutions that govern the distribution of political and economic goods around the globe. Furthermore, due to the moral and empirical complexity of problems of global justice, addressing these requires a normative approach built on observed empirical complexity. While theorists of global justice make attention to political, economic, and social structures central to their concerns, a broad range of empirical evidence from various everyday injustices and crises demonstrate the need to disaggregate empirical experiences of injustice by age, race, gender, location, and other categories that follow political, social, and economic hierarchies. Through analysis of these hierarchies, we may understand the confluence of forces that affect these groups. In short, a theory of global justice needs to be a critical theory that studies the ways in which social interactions create vulnerability, not a distributive theory that focuses on institutions and outcomes. Such a critical approach will use feminist intersectional analysis to look at the complexity of forces that sustain everyday injustices, such as the disproportionate mortality of particular groups. In the paper, I look at the 2008 global food crisis, survival in natural disaster, and the complexity of poverty more generally to illustrate that there are many dimensions to injustice. Many of these are not known to many actors, and arguably no actor knows all the dimensions. Further, with epistemological modesty, we know that even with our best efforts and time to research and reflect, some aspects of injustice remain out of view to many who do not experience them. As Sen argues, a theory of justice that rules out the possibility that our best efforts could leave us locked into some mistake or other, however hidden it might be, makes a pretense that would be hard to vindicate. Consider new insights into poverty made possible by the Multidimensional Poverty Index developed by Gerry, Foster, and Santos. For example, consider that people within states with the highest proportions of poverty, of people in poverty, experience the greatest intensity of that poverty. They are the most poor in terms of being able to meet their basic needs. Gerry, Foster, and Santos find that in some places, more than others, people are able to convert economic resources into health or education. Moreover, some people are more able than others to convert economic resources into health and education and stability. The particular example of the food crisis and the general phenomena of variability in the intensity of poverty among people with similar economic resources calls us to look at the complexity of forces affecting particular cases of suffering and the broader architecture of global poverty to understand the complexities of injustice. I evaluate distributive approaches to global justice which treat poverty as a violation of human rights, and human rights as entitlements that should be distributed justly. I argue that the distributive approaches offer a clear line of reasoning about global justice, but that the clarity of the theoretical architecture is obtained because some aspects of the complexity of global injustice are left out of view. The theory focuses reflection on the tight causal mechanisms of injustice established in institutional founding moments and seeks elite-driven, popularly supported refounding moments to affect the global basic structure. The unknown dimensions of injustice are theoretically unimportant in the distributive approach to global justice. These approaches need a methodology for attending to the ways in which the familiarity of everyday life's values, practices, and norms, and the aggregate impact of our individual behavior and policy prescriptions around the world function to render some forms of injustice invisible due to the small numbers affected by them, or to our unreflective familiarity with them. While offering arguments for considerations of global justice that may appeal to many of our intuitions about justice and to many of our considered judgments about justice, distributive approaches do not adequately challenge us to consider the full range of moral questions attributable to familiar. Which one? Thank you, got it. There are two numbers out of there, it took me a minute. Anyway, something about how bad distributive justice is. So let's get to the methodology, shall we? So what I'm offering is a methodological development of Sen's reflection on the power to make change and the obligations that go with it. On this vision of justice, justice requires changing the world we live in, not living in a different world. It may be intimidating to approach the project of global justice without the familiar Rawlsian architecture, but the critical approach does have an architecture and a methodology that can lead us to attend to the ways in which injustice itself can seem to be an agent in the concealment of unjust harms. Due to the need to understand the complex causes, normative theorizing about global injustice is a project grounded in empirics. By this I mean not the descriptive statistics of who is poor, where and for how long, but rather due to what forces. So I'm going to offer two methodological tools. One I'll discuss a little bit, intersectional analysis, and the other I won't have time to discuss, which are the dimensions of injustice that we need to which we need to cast our gaze. Intersectional analysis, a tool pioneered by Black feminist theorists, is a tool that is useful for studying complex processes in which there are multiple interrelated hierarchies. Intersectional analysis is a tool for understanding the complex ways in which seemingly distinguishable hierarchies can function in confluence to create harms that affect subgroups of a population and to render less visible and less comprehensible the injustice they experience. Intersectionality has also become a commonplace shorthand for reminding an audience to pay attention to certain familiar forms of discrimination. However, the commonplace is a parochial way of using intersectionality to attend to local parochialisms. I distinguish intersectional analysis from the more parochial intersectionality and find it more specific than the impartial spectator position. It is a methodology usefully deployed by an impartial spectator or other analyst. Yeah, you know what? I'm going to even speed along here. So consider Sen's concern that under conditions of income shortage, the resources within a family are distributed according to cultural patterns, which often mean that females experience more acute hunger due to food crisis. For these differences, we need tools of analysis that draw on critical thinking about historical international relations, colonization, decolonization, about gender, race, ethnicity, and about a range of ways in which other hierarchies function through other categories. Consider whether the high female mortality in the 1991 cyclone that hit Bangladesh is a question of justice. Intersectional analysis reveals what data about poverty cannot. While the cyclone was forecast, early warning systems were inadequate. Those who were able to make it to concrete shelters survived. 22% of those who did not, did not. Men learned of imminent risk in the market and other public areas where rural women did not frequent. Men went to the community shelters. Even when they started to feel the effects of the storm, due to a cultural responsibility for their homes and modesty, interviews later revealed, women did not go unaccompanied to such public places. Consequently, the death rate of women ages 20 to 44 was nearly 5 times that of men of the same age group. More generally, empirical study shows that women are 4 times as likely to die in natural disaster as men, and that effect is magnified in poverty to 8 times as likely. The variety in the conditions and context of specific natural disasters has generally made the gendered pattern of mortality in natural disaster invisible to all but the immediate survivors and disaster relief workers. We need to look to the ongoing everyday aspects of injustice, those that cannot be redressed with institutional redesign, but will require long-term individual and social behavioral change. Though these can be facilitated by legislation and certain forms of policy, such policies themselves are not the necessary change, nor can they be relied upon to bring it about. And here I'm going to detour because I know you wanted to have an account of human rights. And I don't usually go off book, but here we go, and I'll be done.
You're doing great.
Thank you. You don't know how much more I have. I was asked to clarify what the view of human rights is underlying this, and I think the distinction between political and social and economic here would be helpful. So how many of you have a power drill? Okay, even in a political theory audience, we have a decent amount of power drills. That was the first thing I bought, actually, when I graduated college, because I wanted to build a loft bed. You don't have a power drill because you want the drill. You have the drill because you want the hole. And not even the whole. What you really want is the rights enjoyment. You want to have the thing that you want. And I believe that the distinction that we're looking for here between political construction of rights and rights enjoyment is the difference between the drill and the whole. So I'm going to stop there. I hope I've given you a sense of the way in which a critical theory requires a methodological approach to non-ideal theory. Thanks.
The Sufis say we are the sons of time. So we see the time and we move. So, okay. I think Fauna must have made an error in inviting me here, because I am the only odd guy of all the people that you've heard since morning, and also Professor Sen last night, because I am in religious studies. And what has religion to do with justice, right? I come to the topic from the groundwork that I do. I am an activist, and I work with the groups and the peoples, and I work at 2 levels. One is to empower them through democratizing religious knowledge, and the other one is to talk to the religious leaders to create a partnership in the global justice. Global justice cannot succeed without the partnership that we are looking for among the people of world religions. I think one of the most important gifts that Professor Sen has given us is the introduction of the 2 terms, niti and nyaya. Both are the gift of Hinduism to the world. And I can say with clarity that we need that language to penetrate those areas of human interaction where we do find injustices occur quite often and frequently unnoticed. Religion has a role to play. When I was part of the advisory commission on the Constitution of Iraq, one of the things that we were working for was to help women identify their rights within the system that was not willing to give women their rights. And this is what we call the Sharia system, the Islamic legal system, that does not see woman as an equal of a man. It sees woman as someone who complements what man achieves at the end of the day. But the fact of the matter is that both in Iraq and Iran, where I have worked with a women's group, women are the ones who are fighting injustices. Women are the ones who are providing with what we call the resistance to injustices, and where the governments fail, it is the women's group that have stood up for something very important. And I'm asking this question. Some of these women that I know in Mashhad, for example, in Iran, they were taken off from the government services, from the professional services, after the Islamic Revolution takes place in 78, 79. In other words, they were classified from the government administration, from professional services. They could have taken a revenge and said, we are not going to do anything for the society. And we found, and this was the research funded by Woodrow Wilson Institute in Washington, that let's see what women are doing when they are deprived of their rights. Not only are they deprived of their rights, but they are also deprived of their dignity to work in the community as equal partners with men. And instead of revenge taking, the women groups in Mashhad and other places are working what we call in the public services. They provide the services where the government has failed. They provide the philanthropic organizations where the government doesn't do anything in those areas. And they go unnoticed. They're the silent wage. They are waging peace, but very silently. They don't make too much noise because they can be imprisoned. But they provide these services. I ask this question, where did this motivation come from? You and I are not willing to say religion has anything to do with it because we have a secular bias. In the entire volume that Professor Sen has written, he has avoided any kind of entanglement with religion. Even Akbar's religion has been described as Rai Aql, is the path of rationality. Whereas Abul Fazl, the historian of Akbar, in Akbar Name says very clearly that the religion he introduced was Din Ilahi. It was the religion of God that he introduced. And under that, umbrella, he wanted world religions to come together and talk to one another. What I'm searching for is the partnership of religion in the global justice. And we cannot expect, especially I'm talking about those areas of the world where injustices are happening every day, where minorities are deprived of the very norms and the rights that they deserve to be given as human beings. We want to see how are they dealing with those issues. I was invited in Indonesia to have a workshop for women. And the whole idea was empowerment of women, how to become empowered in knowledge so that they can fight male jurists. Because jurisprudence is controlled by male. It's a male domination. And all the terms are defined by them and all the rules are made by them. So at the end of the day, women do suffer because they are never the subject who are asked exactly what do they need as far as their needs are concerned. And this is a story you can repeat everywhere in the Muslim world. And those stories we don't hear many, many times because our work is in the public arena. And the public arena is dominated by a peculiar kind of discourse which we call public discourse, in which religion has nothing to offer. In fact, religion must be kept away because it cannot do good things, but it can spoil good things. It can divide people. It is intolerant. It's not capable of generating what we call inclusive theology. And therefore, we run away from it. We say, well, we'll keep it at a distance. But what we have discovered is that there's a lot of sensibilities among the people. And I'm using here Darwin, philosophy. There are three terms which have really determined relational ethics. And those, I think, elements are extremely important for us to explore. I have time in front of me. I don't need reminder. Yes.
No worries.
Yes. Usually I'm very good at stopping at the right time. Because I get disturbed when I'm getting this. Thank you very much. Yes. My chain of thought. Justice cum justice. Well, that's what we wanted to find out. How do we become just? And I think that when you work with the people in everyday situation, realize that there is something else motivating them. And that motivation is the language that you and I need to adopt in the institutions of global justice. Because that language is away from us. We have the secular bias, and we don't want to deal with that language, and that language is based on the Darwinian principle of sincerity, sensibility, and sacrifice. The world is crying out against injustices. We like to work with statistics. We like to work with things that we can manage, we can pigeonhole. This is what we academics are good at. But what we really need to do is go and step into the shoes of those people who are poor, those people who are, treated unjustly. And that's where we find that Ashoka was right. Chandragupta was right that he was able to hold the state. But Ashoka was right on the one very particular issue that the Quran is reminding, Inna Allah la yughayyiru ma biqawmin. God doesn't change the condition of the people until they begin to change themselves. The revolution has to begin somewhere. It is not going to come from the top. I have worked with the Human Commission on the human rights, and there I find the same problem, that we are talking a language that is not touching the people, that's not touching the government. We are working with the groups who have a different need to understand from us, and their question is, what life is worth living? And that's the crux of the moral philosophy. How can we talk about justice and not talk about the investment that life needs from us? And this is where I think my whole process, whether in the book of human rights or the other book that I have written in the Islamic Roots of Democratic Pluralism, I am trying to talk to the Muslim religious leaders that you better check your normative sources, that you cannot engage in discrimination against minorities if you know your sources well. And I think partly my victory was on the day when I appeared in Darul Ifta in Cairo. In Darul Ifta, we were 8 professors who were sent by the Peace Institute. And we went there, we were supposed to talk about interfaith dialogue. Rather, I should say, interfaith diapractice. We use too many words, but we show very little action. It's the women of Netherlands who have taught us that we need to go beyond the dialogue to diapractice. For diapractice, we need to know the language of the people. And believe me, that day when I started speaking English in Darul Ifta in Cairo, they were all talking to one another, and the moment I spoke Arabic, they kept quiet and heard. And that was the day of victory, because they saw for the first time that there are American professors who come and will talk to us in our language, and we will be able to convince ourselves that there is a room for building bridges between peoples. Abrahamic traditions are rich. Judaism has taught us how to be just. Christianity has taught us how to love our neighbors. And I think other religions, Hinduism, Buddhism, Islam, they're all talking the same language. But what we have is, we need to convince the religious leaders to re-explore their resources so that we can have a better world in which we can live. Thank you very much.
Well, I have the dubious honor of speaking last today as the last paper, so I wanted to thank the audience first for sticking it out all the way through. Thank you to Fana and Gerry for giving me a good reason to come home and see old friends. And also thank you to Professor Sen for writing this book, and also a number of your other works on capabilities, freedoms, and human rights, which have very much informed my own work. So I should say before I start that I come to this conference from the perspective of international relations and not political theory or philosophy. When reading Sen's remarkably wide-ranging contribution to our understandings of global justice, I found myself feeling sympathetic towards, and in fact agreeing with, much of what he was saying. In particular, I found myself applying much of what he was writing regarding the problems of having a singular global standard to the actors that I know best: human rights, non-governmental organizations, or NGOs. Too often in the world of human rights, and furthermore in the work of NGOs, we see sweeping statements that criticize state or government actions, buttressed by citations to international legal standards. International law forms both the basis by which states are condemned and legitimizes the activity of NGOs as monitors of those statutes. For Sen, this reliance on legality is open to critique. After all, deeming a behavior illegal or unacceptable via legal standards is certainly an incomplete method. Law is not the only way to express moral outrage or create normative constraints. Sen urges us to think beyond these hard laws and move to softer conceptions that still hearken to the underlying conceptions of justice without the attached language of legality. In other words, to understand human rights as ethical rather than legal claims frees us from the constraints of definition, precision, and prosecution to enable other ways of ensuring the protection of human rights. While I think generally speaking, IR scholars overly rely on legalization as an indicator of international norms, I think in practice legal standards remain a necessary and crucial component of the work of NGOs. In other words, it is the best tool in their toolkit. NGOs are often the only actors willing and able to comment on human rights conditions around the world. Their work is instrumental to how UN agencies view human rights and how countries know about the violations going on in other states. In other words, NGOs play a key role internationally in providing information on human rights violations, and they are often the only actors with detailed knowledge on other countries' rights performances. In the world of human rights, emphasizing the legality of, rather than the morality of human rights, is the only tool with which NGOs can feasibly combat human rights violations in the world for two major reasons. First, NGOs are not, quote, legitimate international actors in the same way that states are. They lack the official standing that can be generalized to a number of different contexts. So while NGOs can be certified domestically or register for consultative status at intergovernmental organizations, there is no standard by which they are recognized. As such, many of them have turned to international law as a way to justify their existence in the absence of other alternatives. Second, in terms of enforceability, law is the only way to go, even if it is a weak tool for not just NGOs, but any political actor. It becomes the most important way to create justice via NGO advocacy. Oftentimes, in fact, NGOs refer to human rights in terms of what they call justiciability. That is, how well can norms or ideas be enforced through the use of international or domestic institutions? Can we fight this out in courts? Can compliance be monitored? It was for their perceived lack of justiciability that prominent human rights NGOs such as Amnesty International and Human Rights Watch refused to take on economic, social, and cultural rights until the late 1990s. For many of these types of rights, the identification of the violation, the violator, and the remedy, which form the core aspects of evaluating justiciability, remains elusive even today. As many of you know, NGOs working on human rights primarily serve as monitors of international law. That is, much of the time, they engage in an activity known as naming and shaming. Essentially, this is the practice of saying, we know what you did, and we're going to tell everybody. This kind of activity can range from writing detailed reports, creating press releases, engaging local populations in projects, or human rights education campaigns. One of the ironies of human rights is that while they are designed to be a buffer between the state might and individual freedoms, states are also the primary enforcers of human rights. Thus, they are simultaneously the targets of human rights advocacy and the ultimate enforcers of such claims. Using law, therefore, gives NGOs an additional basis by which they can shame states, by engaging not just moral and ethical claims, but grounding them in international documents to which a state has agreed, or to which many other states have also agreed. Legality can substantiate moral claims against a particular state's behavior, and it also creates a further ethical demand. Not only are states engaged in human rights violating behavior, but also a violation of a law to which they have agreed. Through their work, NGOs have a role in monitoring compliance to existing law, but they also have a hand in creating and shaping various international legal instruments. Without NGOs' work, international treaties such as the Convention Against Torture, the Ottawa Convention Against Landmines, and many others would not have been possible. NGOs thus have an additional reason to rely on law as a primary tool of monitoring because it provides a way through which they can directly shape human rights policy. Moral claims thus translate into enforceable edicts. The utility of law becomes apparent when powerful countries such as the US refuse to sign on to the International Criminal Court, or its refusal to use the T word after American actions following 9/11 generated controversy and accusations that it violated the Convention Against Torture, among other international human rights instruments. NGOs can shape the norms of human rights through their work on legal measures to reify ethical claims. I think there's another reason to consider the importance of law for NGOs. As it becomes clear that human rights are not violated just by states, and that other kinds of actors are also to blame for human rights violations, such as multinational corporations, law becomes a bigger ally in the protection of human rights. The actors I focus on in the memo, multinational corporations, span borders and distribute products, often on a global scale. If their practices violate basic rights, such as protection of workers' rights, how are NGOs to tackle these issues in the absence of law and regulation by the state? We've seen in the past the success of economic boycotts, such as the boycott of Polaroid because of their use in South African ID cards during apartheid, but those have been far and few between. When the same multinational conglomerate owns tens of coffee brands worldwide, how do fair trade activists take on such a target? Now, sometimes NGOs might be able to launch their own brand alternatives, which has happened in the case of Oxfam. But more often than not, they encourage states to help protect workers from structural conditions created by the market. Or they can ask states to enforce laws against abusive or negligent behavior. Even for a relatively delegalized set of norms around fair trade, for example, NGOs need the power of law to help achieve compliance to the ideas that they promote. This is an area of rapid development for human rights NGOs, working on corporate social responsibility and linking the action of business to human rights. NGOs are working on how to make claims against businesses justiciable, and part of that relies on using states to help remedy violations and regulate the violators. I would like to conclude by recognizing that despite the emphasis in this presentation on the importance of legalization for NGOs, it is worth pointing out that the most influential human rights document in the world continues to be the Universal Declaration of Human Rights. It is an aspirational and an unenforceable document that continues to influence more NGOs in terms of creating a rallying cry around the rights that they advocate. It also lacks the technicality and legalese of subsequent treaties. And for that reason, the Declaration serves as an accessible platform from which to promote rights. The Declaration is adaptable to a variety of local contexts and new issues, thus allowing for adaptation for different domestic situations. Because of its openness, the Declaration allows NGOs to bring issues not formally considered by legal documents at the time and incorporate them into the language of human rights. For example, the fair trade movement, Aboriginal rights, and LGBT rights. This all contributes to the goal of eventually creating an international legal structure around these types of rights. Thus, the growth of international human rights demonstrates that law has the capacity to grow and adapt to usage in local contexts, precisely what NGOs do when they make rights claims justiciable in particular instances. Creating justice through monitoring requires that NGOs be able to ground their claims on particular cases in some commonly held view in order to provide a basis for that critique. Law provides this common platform, and it provides non-state actors with a valuable tool to realize the justiciability of human rights around the world. Thank you.
Okay, I'm really scared for being punished in case I go over time, so I'm going to do my best to finish this in less than 10 minutes. Don't be not being afraid. I'm going to start off with a little interesting story. It starts off in early 1970s in a famous semi-mosque in the busy city of Tehran, the capital of Iran. A famous character with the name of Ali Shariati, some would call him the Rousseau of the Iranian Revolution, gets up there and gives a very famous speech on Imam Hussein. Now, who is Hussein? He's the grandson of Prophet Muhammad. He's famous for going on to the battlefield with some of his followers and fighting against the caliph of the time, 680, and tragically becoming a martyr for what many, especially Shia Muslims, regard to be a cosmic act for justice. Now, the idea of justice, and especially Shia Islamic tradition, meant very much of going up to the oppressor and dying for the cause of God. Now, what Ali Shariati, this interestingly French-educated Shia intellectual, reformulated was this, that in fact Hussein, regardless of the fact of going up there and being defeated, the very fact that existentially he chose to go in the battlefield and be defeated was an act of justice in itself. That was a revolutionary idea, because he was borrowing much of his arguments from, in fact, from Sartre, from Fanon, a bunch of different third world intellectuals, and creating something very unique in Iranian history, which eventually, also Shia Islamic history, which eventually affected the society for years to come. In fact, what's interesting is that Marxist-Leninists used Shariati's revolutionary rhetoric of justice and actually fought the Pahlavi regime, which eventually fell in 1979. What's interesting is that Michel Foucault, when visiting Iran, looked up to Shariati's argument of justice and martyrdom and tried to reformulate his idea of action by using the Iranian discourse of political revolution. Now, go to 2011 January. Someone with the name of Wael Ghanim comes up with a fascinating new discourse, and this is happening, by the way, online, on Facebook. This interesting theory of justice, which you are able to find online, is that you're no longer looking at necessarily martyrdom as a way of discovering justice, at least in the Muslim, so-called Muslim traditional context, but you're understanding justice as a form of a collective action which can be mobilized in various ways, in which Facebook could be an ideal way of doing that. Now, these two examples I just give you are really fascinating, reinventive ways in which two very different kind of Muslim societies for the last 30, 40 years have rethought the Islamic notion of justice from its classical period to contemporary times. In fact, I would argue much of these two traditions that were invented by these two characters are very much in negotiation with very different traditions of justice that have been producing throughout Islamic history since the 7th century, when Hussein famously died in the Battle of Karbala. This, I think, is central to what I believe also central to what Professor Sen is also doing in his fascinating book. What he's doing is that he's rethinking the Western Enlightenment classical tradition of justice in so many radical ways in his book. And he's doing that in many ways that people like Martin Heidegger, Wittgenstein, a number of different, you could say, even Rory did, by challenging the epistemological notion of justice, by looking at justice in terms of action theory. And I think that's one of the most fascinating themes that comes out from the book as I'm reading it, while especially flying from Iran to here, which was fascinating, 10 hours of reading. The anti-transcendental thrust of it, and by the way, all of this will come back to the papers I'm going to briefly discuss, is this really reliance on human agency. We see this working out from the utilitarian philosophy that goes back, to, of course, to Hobbes and all the different thinkers, and trying to focus on the theme of human agency. This is why I think he's closer, without if I'm probably even realizing it, to someone like, again, like Hannah Arendt, which Tracy Strong brought up, and even Wittgenstein, than some of the famous utilitarian thinkers. He's trying to rethink justice in terms of certain subcategories like rights, norms, and freedom, not in terms of institutions, but as human agency in the making, the ability to produce new possibilities, to determine one's life form with the capability to function in a given society based on public reasoning. Now, having said that, not to confuse you, I think 3 papers here wonderfully revolve around this fascinating theme of human agency. We got Wong's paper that really focuses on laws. And she has, I think, a very minimalist definition of laws that, look, sure, Professor Sen kind of says, oh, laws are not important as a set of institutions, but nevertheless, when we look at IR and international relations, we see that laws do matter, especially on a grassroots level when NGOs are able to look up to certain laws, especially human rights laws, and try to come up with some form of mobilization in order to preserve some kind of justice on the ground. Now, much of this, by the way, reminds me of the famous philosophy of myth, the way myths basically move people to act in a certain way. We saw that in 1960s and 70s with the Marxist movement, the way the idea of revolution as a myth enabled them to motivate and do so many incredible stuff, and sometimes, of course, very nasty and tragic. I think Wong is in many ways also bringing up, of course, she's not focusing on the theme of myths, but nevertheless saying that laws are important in the way, of course, the way Professor Sen is developing his idea of justice, which is really about not necessarily institutions, but human agency. Kaufman paper also looks at freedom and capabilities approach in terms of understanding the way people could have the ability to choose and by extension lead distinct forms of life. And I mean, he has a wonderful way of criticizing, Kaufman has a wonderful way of criticizing various different thinkers. But ultimately, I think what we understand again is this reliance of human agency. A kind of a theme that we see with the next paper about the idea of global injustice. And again, I'm going back to Tracy Strong, who's my former professor. He's a wonderful professor, by the way, I have to say, that talks about this negative theory of justice. So let's not talk about, this is the anti-theory of justice. Let's not compose theories of justice, because that in itself is a transcendental endeavor. Here we have to look at justice in terms of what is not, and here's a fascinating paper that talks to us about that theme of human agency, which is profoundly manifested in Professor Sen's writings. Now, the last paper, Professor Sachedina's work, I think deals with a fascinating alternative theme in Professor Sen's wonderful theory of, or anti-theory of justice. And that's the idea of rationality. We know the idea of public reason is all over this book. There's a fascination with this term, with this concept. How do you define public reasoning? And I think in many ways he's challenging people like Habermas, this idea of singularity of rationality. And of course, this is the early Habermas. The later one has changed his views in so many ways. And he's in a very interesting dialogue with people like Charles Taylor, Hans Joas, and the late Shmuel Eisenstadt, in developing this fascinating theme of multiple modernities, how multiple forms of rationalities have developed in understanding different ways of understanding justice, of course. Professor Sachedina's paper is a fascinating, introspective way of bringing about this notion of justice from multiple traditions, all the way from Hinduism, of course, going back to Professor Sen's notion of justice, all the way to Islamic, Christian, and also Judaic traditions. And I think there's a fascinating development of, I guess you could even call it self-realization of justice here in this paper, that I think could lead us to a very different way of understanding a justice of a post-secular kind. That's the most important contribution I think Professor Sachedina is offering here, contributing here. And I'm going to leave it here. I'm going to move to the next speaker. So thanks very much. Is it only 10 minutes? Okay.
Well, these 4 papers, in my mind, form a musical quartet by 4 authors, each of whom is playing a different instrument. So the members of this quartet engage in the classical debates surrounding, respectively, each of the 4 words in the foundational document of human rights, the Universal Declaration of Human Rights. Professor Sachedina is a participant in the debate over the meaning of universal. Professor Wong of the usefulness of declarations. Professor Kaufman of how to empower humans, and I think by extension of what it means to be fully human, and Professor Ackerly on the proper range of rights. This is the Human Rights Quartet. Each of the papers in this quartet examines a significant aspect of human rights, and altogether they reflect on the different but complementary aspects of Amartya Sen's theory of global justice. And after highlighting the positions that the 4 authors take in these ongoing debates, I would like to address a question to each one that focuses on the relationship of their position to Sen's view of human rights and to human rights to global justice. And I would like to proceed in the opposite order than of the presenters. Wendy Wong's focus is on one of the classic pitfalls of human rights, its lax and ambiguous enforcement. Her starting point is the weak hand NGOs, the non-state actors who operate in the gap between states as both enforcers and violators of human rights can play. The NGOs' weakness is particularly visible when they seek to name and shame multinational corporations that are able to avoid national jurisdictions. She suggests that the transition from declarations to treaties, namely the legalization of human rights, the creation of justiciable legal decrees, is the key to the effective operation of NGOs, even if it reduces the range of human rights. Now, Sen, on his part, points out that the moral and public reach of human rights goes beyond the law. And my question is, what needs to be done to maintain as much as possible this broader reach, even as we struggle to legalize these rights? In what way are declarations and treaties complementary or conflictual? In fact, could NGOs strive to make rights, to legalize them if it was not for the moral suasion that they exert outside the confined realm of law? Professor Abdulaziz Sachedina's paper is focused on a different aspect of human rights, namely the tension between the exclusivist or sectarian nature and consequent selective morality of the great religions and, of course, the universalistic aspirations of human rights. He seems to suggest a way around this dilemma by arguing, in his paper, that niti, the Indian notion of justice that Sen makes use of, is a location where reason and revelation might converge and make room for a common human destiny. Sen's own approach is agnostic towards religion or religious justice. And my own question, therefore, is how does one prioritize human rights in cases where reason and revelation find themselves in conflict? More broadly, and pointedly maybe, can there be a universal framework of justice that is not secular, or at least pluralistic? Alternatively, can religions be viewed as local versions of justice, given that notwithstanding the sectarian approach, they also profess universalistic aspirations? Brooke Ackerly, on her part, examines everyday injustice, namely the creation of human vulnerabilities to the process of social interaction that go above and beyond injustices that are perpetrated by institutional provision or differential institutional provision of resources. She offers to anchor global justice not only in the distributive approaches, but in this intersectional methodology that disaggregates, unpacks, and brings to light the complex and interrelated multiple social hierarchies. The question I have for her is, what are the obstacles? Is whether the obstacles that are potentially created by focusing on these multiple sides and discourses of exclusion and discrimination. In other words, of the many ways in which human rights are violated, do they make it impossible or difficult of putting the notion of global justice together again? How much room is left in the methodology of intersectional analysis for universal human rights and for global justice? Finally, Professor Kaufman examines Sen's theory of individual capabilities, which, by combining functionings and opportunity freedom, shift the notion of justice away from instrumental to a more widely conceived range of human rights. To me, by the way, this close bond within human rights, in particular positive rights, capabilities, and freedom, serve as a powerful vision of what it is to be human. Kaufman approvingly points out that Sen privileges the opportunity to be free due to different causes or a variety of causes over personal control, and consequently, Kaufman concludes that Sen's emphasis on substantial freedoms does not diminish, but rather enhances the egalitarian approach to justice. Since Kaufman does not critique Sen's approach, but rather seeks to clarify and defend it, I think a good question to ask would be, how does Sen's approach deepen our understanding of human rights? In particular, what does the perspective of comparative justice bring to the pursuit of human rights, especially since human rights have their own transcendental version of justice? Thank you.
Well, again, a wonderful session. I think I'll go in the order. I wouldn't comment too much on the commentators because they themselves are commenting, but I will begin by asking, taking a clue from Gershon's question to Alexander Kaufman about how does it deepen what I was trying to suggest. Well, I think the way it deepens, as I see it, is to make clear what is the way it can be used and in what respect. You see, I think the questions of Cohen and Dworkin are quite central to the engagement because we have been together, we have taught classes together. There was, in fact, a time when we were, there was a class offered which was Cohen, Dworkin, Sen, and Parfit. So these are territories that we have traversed, and you know, not surprisingly that I rather agree with Alexander, very much so. But more than that, I think it's not the kind of question that Andrew Williams raised, to which Ronnie gave a very, I thought, a very over-rapid answer, and it made clear why it is so. So I benefited greatly from understanding more clearly how to engage in these debates. And you know, whenever Ronnie is engaging in a debate, I think there is a lot to discuss. When he doesn't, in his last book, he just makes a passing remark on my book saying that he read it, but he thinks it doesn't add anything to it because even before he read the book, he knew that slavery was a bad thing. Now, to think that that was what I was saying in the book is a kind of amazing discovery. And therefore, to me, it's really wonderful that what Alexander Kaufman did, and it's beneficial for me, and definitely, you know, I hope it's beneficial to others too. And I could say something similar to Brooke Ackerly said, and I don't remember the occasion when we first met in Williams College. You were an undergraduate then?
I was a student of Steve Young.
Okay, good. Well, we should have chatted then. But I very much agree with the focus on power to make change and the importance of critical theory on both the points that you made. And I think this issue of power is quite an important one to engage. I think the capability literature is sometimes criticized, I think justly, for not using the language of power so much. Now, formally, there isn't a distinction. To say I'm capable of doing A is not different from saying I have power to do A. But there is a language difference, which is very big, because in the case of power, the suppression by others, in Brooke's case by institutions, but it could be also, well, in the case of appetite, both institutions, but a class and but a category of race. And power focuses on the more conflict-based aspects of capability, which requires certain type of focus, because it requires a different engagement about how to make the change on which Brooke is confining herself. A person who discusses power a lot, Steve Biko, to go back to South Africa again, and one of the things he points out that the real difficulty with the powerlessness of the blacks in Africa is that it's not only that you don't have what you would like to have, and we have reason to want to have, but that you can't even express yourself. That, as he put it, that you spend the day telling the white superior, quote unquote, calling him the boss, and then in the privacy of your toilet in the evening, you curse him. the fact that you can't even express it. This is a kind of tremendous violation of even the power to express that you are being unjustly treated. So I think this issue of the rhetoric of power, I think this is where the capability literature has to come to more terms with it. The literature has grown kind of to an alarming size, I might say, at this time. And I think and there are these issues to be addressed, and power is one of the ones. There's a lovely statement of Andrew and Bevan to say what's the purpose of having power. And in his answer to that, he said, Aaron Bevan was a left-wing member of cabinet who resigned from the cabinet on grounds of National Health Service not covering everything, including dental treatment and so on. So he was a kind of thoroughgoing socialist of that time. But his comment on that was regarded by many people as intriguing, was to say the purpose of having power is to give it away. Well, what could it possibly mean? It's just that if you have the power, it means that somebody does not have the power over you. And then if you give it away, the fact remains still that he did not have the power over you. So I think the point is quite a profound one. You see, in some ways, there's a little danger in the capability literature of emphasizing too much the collaborative aspects. We all help each other, and by doing this, something happens. And I think, to some extent, that's also seen as a fault of my book on development of freedom. Things are more kind of harmonious. In some ways, you advance in each front together, and you don't really take on the really contrary issues that come. There may be people who don't want you to have that. George Soros dropped me a line after reading Development of Freedom, saying that you take the danger of the multinational excessive powers too much for granted, that you assume that it's not a well, it didn't say that, you assume that it's not a big thing, but you don't discuss it as if that you can't change it. But that is a rhetoric to be engaged in. So I think, and I think you were right, and that is a fault of the book. So I think the viewing it in terms of the power to make change is a very good perspective to see it. Now, but Abdulaziz's very illuminating comment, and I'm delighted he was invited, even though he is so surprised that he is. I would say, I mean, I agree with pretty much everything he said, but I'd say a couple of things, well, maybe three small points. One is that it's maybe right to say Niti and Nyaya is a Hindu concept, but I think it isn't for two different reasons. First of all, it's as much Buddhist thinking as Hindu thinking. And in fact, even the last case of quoting Matsanaya being to be replaced, that is a Nyaya-based theory criticizing Niti, is Dharmapal, who is he's establishing the Buddhist kingdom over east of India after defeating the Hindu king in that. So, you know, so the Hindu king had Niti and he wants Nyaya. That's the way it came through. So I think I think you can't distinguish between the Hindu origins or non-Hindu origins of that, because there isn't until the Persians started calling Indians by the land on the other side of the Indus. You know, that identity didn't exist actually. In some ways, the idea that it was all together, somehow one religion, is a foreign-generated idea, in this case, enabledly foreign, namely the Persian. The second point to make is that it's not so much that I suppress Akbar's religiosity. In fact, I'm on record discussing that he remained a good Muslim. And you said Din Ilahi, but more than that, he remained a good Muslim, actually. But you see, the thing to understand is, why did he have Din Ilahi? And along with that, Tariq Ilahi. Tariq Ilahi is God's calendar. These are all the features of combining different aspects of the religion and different aspects of the calendar. Take Tariq Ilahi. Tariq Ilahi is a solar calendar like the Hindu and Buddhist calendar, not like Hijra. It, however, begins with Muhammad's movement to Medina, and so it has clearly Islamic origin. And there is royalty too. Date is fixed on the date, that is, on the day in the Hijra calendar when Akbar ascended to throne. From then onwards, it falls behind because it's solar and is going at a less speed than Hijra is going. And it's, you know, you can see different aspects of it. He was and I have to come back to it because, you know, sometimes, I mean, his religiosity was important, but I think he did feel the need as a political king of a multi-religious country with a majority of Hindus to give expression to a political unity of the nation. I think he's concerned about that question, as Abul Fazl himself in Akbarnama says again and again. He's very concerned about the diversity of the country, how to unite. So in calendar, in religion, in having a uniform code, in protecting minorities as well as protecting any persecuted, in this case possibly majority, there is a political vision which I think it may have religious origin because so many of our thoughts have religious origin, but it was more consciously a political idea. And in some ways, when Western thinkers think of these in primarily religious terms, they miss out the fact that Akbar's engagement is not different from what the Greeks are engaged in and many others were engaged in. They were facing similar problems, and he was a devoted Muslim, but he wasn't putting his Muslim existence above that of the political responsibilities of being a king of a multinational country. So I won't trace it all to religion, excepting in the way that so many of our ideas of justice are formed by religion. Ultimately, that I think is indeed right. So I think that's what I would mention. Now, Wendy and I do have some disagreement, I think. And the disagreement is not, as I think Gershon makes clear, that I think that I'm not saying that law is unimportant for human rights. It's extremely important. But as he puts it, we have to go beyond the law. And if I may, and as Babak Rahimi said, is the issue of the public reasoning, which is central. And I'm trying to emphasize the role of public reasoning in the context of human rights. And it is really, without any kind of embarrassment to the importance of legality in law, we have to see to what extent it goes beyond. It goes beyond for at least three different reasons. One, when we invoke, say, Universal Declaration of Human Rights, these are not law. This is an invitation to law. But why should these be invitation to law unless there's some ethics backing it? The Declaration of Independence, it begins with the declaration that people have these rights. And now we are trying to legislate them in. The French Declaration of the Rights of Man begins with ethics and then proceeds to law. Now, this is a point that Herbert Hart makes with, I think, compelling clarity in a paper in 1952 about the basis of natural rights, and discussing the French Declaration of Rights in particular. And so as he argued, instead of taking the Bentham view that rights are child of law, he's basically arguing that rights are that the concept of human rights is parents of law. It makes you motivate it to make those laws, and that has happened. And this is where the religion has also often played a part of what you put into in a law, guided by that. And so I think in some ways there is a kind of parental role of rights that are pre-legal and proto-legal, rather than post-legal. So that doesn't in any way reduce the importance of legality and the post-legal status of rights. So that's one point. Secondly, I don't think you will get the effectiveness of law without the public reasoning being an ally. I think one of the good things to look at is that unlike in India and in South Africa, where the Human Rights Commission has a legal status recognized by the legal system, in Pakistan it doesn't. It just is an NGO, nothing else. A mere NGO, if you would like to say. But why has it been so effective in so many different ways? They've agitated for press freedom, which to a great extent they have managed to get. And people often forget how much that we know about the terrible things happening in Pakistan comes from the Pakistan press itself. It had agitated for rights of minorities. It has agitated for the rights of Christians not to be persecuted even in the present very difficult circumstances about the kind of controversy that killed Tasir and the governor of Punjab and also the sole Christian in the cabinet. The Human Rights Commission have tried to take a position against very difficult odds. Sometimes they have succeeded and sometimes they have not. And one case where they did succeed was that a lot of Pakistani citizens who were very aware of what's going on in Swat Valley under the control of the Taliban wanted the army to intervene. And the army was most reluctant to intervene, either because it didn't want to take that on, or because within the army, as you know, Pakistan army is a very divided army in many ways, the people did not want. What made the change, and that was a really dramatic change, was the whipping of that young woman in the Swat Valley, which an activist in the Human Rights Agency videoed by pretending to make a long telephone call. In fact, in agency photographs, you see him making a long phone throughout. Now, he was taking incredible risk. If he had been caught there taking a video, he would have been killed then and there. So he wasn't. He succeeded in get it out and put it in the media. It came out in the Geo and the other channels straight away. And there was a gigantic impact on the Pakistani civil society. They did not want that to continue, no matter what their view is on religion, politics, and so on. So the army was in a position that way it had to intervene. Now, of course, some of it is being undone now. We don't know. But certainly for a while, the fact that the Taliban-controlled areas, the rights of women, which had been reduced, did expand because of Pakistani military coming in, was almost entirely the result of human rights movement outside law, and very courageous movement too. The third point to recognize, and that is Mary Wollstonecraft's point, that there are cases when you don't want to legalize it because they're not quite the right domain for legalization. I mean, one of the examples that I use in the book is the wife's right to be consulted in family decisions, extremely important right. And in the development of freedom, I discuss how so many things, including fertility rate, mortality rate, child mortality, etc., all depends on that. So it is a very important human right. But would it be a particularly good way of, sort of legalizing, requiring the husband to consult the wife, and if he doesn't, he's taken in custody and handcuffed to go to the prison? I don't think this is going to be the way of doing it. The Mary Wollstonecraft spends a lot of time, and that's why I'm really shocked by the fact that how little Mary Wollstonecraft is read. Because in her two books, Vindication of the Rights of Men, which is really about slavery, it's a critique of Edmund Burke is addressed to Burke, saying, and it begins with extraordinary statements saying, on what principle Mr. Burke could support the American Declaration of Independence, I cannot begin to imagine. Now, what could this revolutionary English woman supporting American Revolution, French Revolution, be meaning by that? Well, it's quite clear what we previously explained, namely, how could you demand independence and these rights for the white people and not for the slaves? And so that's a complete betrayal. And there comes a big discussion as to why you cannot deny human rights to some while arguing for human rights for others. So that's a kind of profoundly important document. The second, Vindication of the Rights of Women, let's say singular, as was the first one, men, I think this was written at a time when Mary Wollstonecraft had got convinced that unlike the French illusion, they call the rights of men, they're supposed to include the women too, that they didn't leave out the women, but they did want to bring in she felt that you have to bring in the woman's case separately because it wasn't receiving enough attention. And then she discusses all kinds of ways in which these rights were violated. And what do you do? And he said, yeah, some of these are matters of law, but many of them are not. Many of them are public agitation and beginning to get moving the media, getting people to pay attention and so forth. So I think these things will remain. And so law, important as it is, would have to be supplemented by the public reasoning and public agitation thing. And they are like Babak, Rahimi, and I also believe that public reasoning has an enormous scope, really. And I think we hadn't quite seen how effective it could be still. I mean, it had been effective in many areas. Could be much more effective, even in, I look at the violation that's going on even in India, despite the high growth rate, how far behind it remains in many of the human rights issues. And I think the question is to have greater faith in public reasoning, not be sort of compelled by into the belief that since India is having high growth rate, then everything is fine. We do need more public reasoning. It could achieve a lot more. I think somewhere in the book I quoted, I'm not sure whether I did or not, but I wanted to, that lovely statement of Proust with Nadine Gordimer, quotes actually several times. And it's a lovely statement saying, don't be afraid of going too far, for the truth lies beyond it. And I think the same thing could be said about public reasoning. One shouldn't be afraid of relying too much on that. Thank you.
We have, if I can figure out where I am and what I'm doing, we have time for questions, and Anthony will. Who has a question among the participants here? Yes. Wait for because it's on UCTV. Please wait for the microphone.
It's not much of a question, but an attempt to sort of connect a few things. Now we've talked so much about public reasoning, it's probably worth reflecting a little bit more about what that entails. And perhaps some of what was said in one of the earlier panels about political rhetoric is connected to that we can think about public reasoning in a way that involves persuasion rather than speaking in some kind of a neutral form of reasoning that seems to sometimes demand to be devoid of religion and insist on its secularity, as Gershon was suggesting. I guess I'm disagreeing a little bit and agreeing with Professor Sachedina that religious traditions are rich. They are sources from which people derive inspiration for public reasoning. And if one wants to persuade, one has to work with the frames within which people are willing to think. And I think in Arabic-speaking countries, for example, intellectuals and activists, human rights activists, have long learned that to refuse to speak the language of religion is to make oneself irrelevant.
Okay, Francesca Minetti from UNICEF.
Thank you. I'd just like to pick up on what you just said and go one step further. And the role of NGOs, in a way, I have some complimenting what you've said, Wendy, which is that I think the role of NGOs doesn't only have to be limited. NGOs who want to pursue and promote human rights have perhaps focused too much, as has the Office of the High Commissioner of Human Rights, in my view, and I can say that because I work with the UN, right? Have focused too much on the blaming, shaming, and in particular on violations. So human rights becomes associated with violation rather than human rights becoming associated with the ideals of human rights. And I would hope that we can promote a role of NGOs as very important members of civil society, so not as separate, but as part of that, in a discourse that leads to the increased discussion of the fundamental values that we all agree upon and that are consistent with what we have framed, or some have framed, or some recognize themselves as being human rights, and be promoters of that rather than pointers of the violations, which in an extreme would lead to putting all the violators in jail, which is not what human rights is about, right? That, and then I would just ask one favor in a way, that is, as I've heard in many times today, the reference to poor people. We talk a lot about injustice here, and there's a lot of reference to poor people, or the poor. And I would just ask that we consider to not talk about the poor, but that we consider talking about people living in poverty, which is a very different concept. Thank you.
Okay. Yes, I said questions, but comments are probably as welcome, if not more welcome. And I want to, one moment, any of the visitors have a question? Any of the attendees? Or think about it, and we'll come back to you. Oh, there. Well, no, Ivo, you had a turn. It's just one shot.
Serve the public.
Yeah. All right. Okay. I want to call in someone new.
I'm new.
Yep.
I just wanted to follow up a couple of the remarks that Professor Abdul Noor was making. It was only when Professor, is it working? Can I be heard? Can I now be heard? Professor Sachedina made his presentation, and then Professor Rahimi made his presentation, and Professor Abdul Noor just made his comments on these comments in turn. It only then occurred to me the extent to which we have not placed many conversations about religion on this agenda. And it raises an interesting question: which form of religiosity can one properly include in this conversation? The matter of rhetoric has a lot to do with it. When we were doing our piece on Gandhi, which I don't know whether it qualifies as doesn't quite qualify as a merely rationalist account. When we were doing Gandhi, it occurs to me we often use the word love, which really doesn't figure very often in academic conversations. It's a matter of embarrassment because it is a matter of either a sign of religion or it is a sign of the erotic or a sign of the feminine, but probably not a sign of itself. But it is connected with religion. So I'm interested in the fact that both with respect to religion, we don't have a lot of conversation about it here, and that's interesting. And we have questions of rhetoric, which we probably need to clarify.
All right, new hand, Peter Gervit.
I qualify as dual since I'm old and I live in San Diego.
And I've heard everything that
And you've heard everything I have to say. Thank you, Gerry. I really appreciate that. That was a wonderful framing. So
It's just the opposite. Your contributions are
no.
always...
I mean, my comment actually is a lot of the things, many of the things that you've all written, Amartya and other people talk about this, but I'm a little, it hasn't been raised much. So I'd like to, which is that by talking a lot about rights as individual attributes, we don't talk very much about some individual, the fulfillment of some individual attribute that we might have that comes from being part of a group. And religion, in a way, gets me down that path because, in a way, religion, one of the aspects of religion is that you share it with other people. So it's a group attribute, and it's something that you share. And so I'm just curious, and I thought when we talked about rights, local knowledge and things like that, it would be interesting to hear a discussion, and we talk about the achievement of capabilities. What are the capabilities that can only arise as something that you share with other people, and therefore the rights of a group become an interesting set of issues. I mean, in a way, a lot of the discussion happens as what do we think of the way a group treats badly some individual, and that's very well worked out, and not saying that, but there is something about how do we allow groups to do what they do that allows individuals to become a particular something, a fulfillment that they have. You know, we're interested in kind of a lot of the individual rights or the ability to do something, but it's also achieving some essence of person that can only come up with your membership and solidarity that you have with other people. So I'm just curious what thoughts people have on that tiny little topic.
Okay.
That's not what you expected from me.
All right.
Not what you expected from me, is it, Gerry? Admit it. You didn't think I was going to say that.
How about 2 short answers? Okay.
I think
Yes.
we're at the very important turning point in our understanding of the role of religion today. And I think if I can speak on behalf of the world religions, I would say that the main emphasis in world religions has been to create communities. And this is what my colleague David Novak says about the covenant as a whole is a human covenant. And human communities, before even John Rawls has spoke about the overlapping consensus, the human communities were living not fictitiously, but in reality, in cooperation with one another. And I think the new religiosity that we are talking about is the religiosity that recognizes what we call the human need for connection. I think we moderns are extremely lonely. And there is a tension between our claim of autonomy and our belonging to a group. And I don't mean to say that autonomy should be forgotten completely. What I'm saying is that they both have their places. And in order to nurture the right kind of ethical relationship, we really need to work hard to connect people horizontally. And even the group rights today are questionable in the Declaration of Human Rights. We are always emphasizing individual rights. So I think we are at the turning point that we need to somehow think about strategies of connecting human beings and how then that can transpire into even meeting the challenges of injustices. What I have seen in Palestine or in other places, what people have been able to do is connect as a group in order to meet the challenges of really living in the conditions that are not palatable. Humanly speaking, they are very much against, my human dignity.
Okay, let's, sure, go ahead. 2 minutes.
That's generous. Well, the first thing is to say I very much agree with Peter that it's a very important class of capabilities. There is a literature on that. There's a very interesting paper, fairly formal paper by Foster, whose name was earlier invoked, and Foster and Altair. They call it external capabilities. But I would have thought they're not really external, they're interactive capabilities. And belonging to a group, they don't take the view that groups have existence and their capabilities matter, which sort of takes you in a completely different direction. But it's still the human being is the center, and the human rights context, that would be the natural one. But the fact that you want to interact with other groups is important, and it could be therefore one of the things to be taken into account. My second remark in the second minute is that why is it that some of us have emphasized it relatively less? And this is a self-analyzing question. I think, and why is it that for some of us the community identities cause terror? I think for those of us who grew up at a time when suddenly out of nowhere these Hindu-Muslim riots came, and suddenly people who had seen themselves as Indians or human beings or Asians and other things, professional, workers, Calcutta resident, Bombay resident, and so on, suddenly they started defining themselves in terms of being a fiercely defined Hindu or a fiercely defined Muslim. And suddenly there were huge blood flows connected with it. So in some ways, it's very difficult to think about that as it's not the Abdulaziz way of saying the purpose of religion being to create communities, unite. It had the exact opposite effect of disuniting people. So I think that's that's not a reason for not taking into account that people might wish to mix and have those interactive capabilities. But yet you cannot discuss it without at the same time bringing in the disharmonizing, the disuniting features of singular identities with one religious community.
So I mean, my thought is way motivated by that, because in a way that distinction is an important one.
You need that.
That distinction is an important one. If we could think about this in a way that does not legitimate murdering somebody who's they're different, then prevents us from having a discussion where it's legitimate to sustain differences which help form identities. And since that's a very important in the modern world, as we're having multi-ethnic, multi-social states and all that, it's the inability to have a coherent discourse about that strikes me as problematic, because we're so frightened. I'll stop, Gerry.
I'll take 10 seconds just to say that is the reason why this, in my book, Identities and Violence, where Akbar comes into it. Akbar comes into it because the point he's making is that you recognize these connections, and yet you have to transgress it in terms of political rules of fairness in treating different people.
All right, I'm a little concerned because we have two people in the queue who have been patient with me. And we will take these two questions and then conclude the session and adjourn to dinner. Well, eventually.
Well, I think this is in disagreement with Wendy Wong and maybe with Amartya Sen as well. It seems to me that legalization of human rights strikes me as, well, perhaps having some importance, but not being very important. The consensus that it expresses is certainly important, and I suppose expressing it in the covenants strengthens it. But look, people were outraged at torture before there was a covenant that prohibited it. My parents really didn't like torture at all, and that was long before the covenants existed. Subscription to the covenants doesn't make a difference. As far as we can see from quantitative studies, Zaire subscribed to the political rights covenant very early on. Prosecution of people who violate human rights is sometimes a good idea, but sometimes not. Doing it with truth commission seems better in South Africa. Doing it by forgetting seemed better in Brazil. And the covenants do tend to press towards a uniform recipe where it's not appropriate. So why would it matter? Because, I mean, importance is a matter of degree. I haven't said totally unimportant. I think these questions of degree, they do matter. For one thing, if you exaggerate the importance of legalization, I think you're encouraging people to trust in multinational institutions to an excessive degree, because their effective operation depends on great powers who can't be counted on to protect people. Also, some human rights, the economic ones, are by their nature not justiciable. I think that finding the proper balance between them and the justiciable ones is absolutely fundamental. It's the crux of one's judgment of whether to condemn the Chinese government as a whole. And I think that's a fundamental question in U.S. Foreign policy that shouldn't be clouded by the presupposition that the justiciable is the important.
Okay. We're near adjournment, so. Oh, do you want to respond? All right, sure.
I'm going to give a 30-second response since I guess I'm under the gun. Just to respond to both sort of comments, I think I agree that law is not an end, it's a means to different types of ends. So I think what I was trying to emphasize in my memo was the use value of legalization for non-state actors to act. That is, it gives them some sort of springboard from which to make condemnations at the international level or from an international perspective. So public reasoning is, I think, relatively easy to think about when we think about domestic situations. So when you're looking at human rights in Pakistan or India, but what I was trying to sort of get at with this memo was thinking about how it is that international interventions might need a legal basis by which to create conversations and public reasoning around rights.
Thank you. This, in some sense, this question shouldn't probably come now. I'm going to refrain from going on the question of community that Peter raises, and the whole question of how one refuses homogeneity at the same time does not engage in the kind of exclusive acts which Amartya has condemned quite properly. I'm struck by the fact that this entire conversation has been remarkably unhistorical. And in fact, Amartya's book, one of its great attributes is to find examples from 14 centuries ago which exemplify the same kind of questions we have now. So the question which comes out of that is, have there been, over the course of human history, whatever that means exactly, new rights? If so, what are they, and where do they come from? Or has it always been the same? That's not a good question to end with.
Well, I apologize for pushing a little at the end. I'll have you know that I have about 9 or 10 minutes of comments on the questions that I suppressed. So I paid an even bigger penalty than you did. Tracy doesn't believe that people are sincere, but he may be surprised that sometimes they are.
Only the virtuous is
sincere. There will be a reception in the library room at 6:30. The library room is the room where we had our first reception. And then we sit for dinner in the Adobe room at 7 p.m.
The Adobe room is the veranda or what?
Inside. The room inside of the veranda. It's next to the library. At 7.
At 7. Any other? Okay. Thank you very much for your attendance and your participation.